Raylene Worthington have never been to a doctor. Neither one of them. Raylene Worthington did not deny medical treatment to their daughter. They never felt that it was needed.
So some of the opening comments by Mark Cogan, who is Brent Worthington's attorney, as he talked to the jurors about what this case was all about. And we're pleased to have Mark Cogan joining us now by phone from Portland, Oregon. Mark, thanks for taking the time to talk to us. We appreciate it.
You're welcome. Good morning. Glad to be here.
Let me ask you this. When you first got involved in this case, did you envision it as this great battle over religious freedoms within this courtroom, or did you see it as something else?
From the very first day that we met the Worthingtons, we knew this case would be a very important trial. Whether it's a battle between faith and government, that's for you to judge. Our view was that it was a trial as to whether Mr. and Mrs. Worthington were reasonable in how they cared for their child.
I know that this case had generated a great deal of interest out there, and for a lot of very good reasons, I imagine. During the course of your jury selection process, what were you finding in terms of what these potential jurors knew about the case, and whether a good portion of them had already formulated opinions about it?
I think that many jurors, many of the potential jurors did have preconceived ideas about this case. We had a detailed questionnaire that was filled out by the jurors, and many of the prospective jurors did reveal very strong biases against our clients based on the intense, negative, and very selective media coverage of our case prior to trial.
Were you satisfied? And obviously, jury selection, you never really know what you're getting in the box. You can get a sense of some people. But were you satisfied that you were able to glean enough people who hadn't reached those very hard and firm conclusions about your clients that they would get a fair shot inside this courtroom?
Yes, absolutely. By the end of the week of jury selection, we were very pleased that we had chosen a group of jurors who were not biased against our clients, who would give us a fair shot. We were also looking to have jurors who have been parents and who could appreciate the complicated decisions that all parents make as to their children's well-being.
Now, looking at the legislative history that we've seen in the state of Oregon with regard to these types of cases, it looks like it was a serious hurdle for you inside of this courtroom. Talk about what the Oregon legislature had done. I think it was back in 1999 when they essentially said, you know what, your religious beliefs are not going to provide a defense for you in this type of case. How did that all come about, and what sort of hurdle did that present for you?
Well, in 1999, the Oregon legislature removed an affirmative defense for faith-based practices that previously existed in the law pertaining to manslaughter in the second degree. That defense still is on the books for manslaughter in the first degree, but our clients were prosecuted for manslaughter in the second degree, so the 1999 legislation stripped them of that affirmative defense.
Now, you've tried cases for a lot of years. I would imagine, I spent a lot of years as a defense attorney, but also quite a few years as a prosecutor. I would imagine that perhaps a prosecutor might have stood up before the trial and said, Your Honor, if indeed the legislature has done what we see they did, there should be no room for any conversation inside of this courtroom about the Worthingtons' religious beliefs. It is not allowable as a defense. Was that argument made at all, and was the judge at all inclined to keep that out, or were you allowed to make those arguments freely?
Well, we knew that we were not going to try this case as a religious freedom case. The defense, neither myself nor Mr. Neidig relied on religious freedom in our arguments to the jury.
So your focus has been essentially a factual one that, and correct me if I'm wrong, that your clients basically did not ever comprehend that the medical conditions, maybe we say, of their daughter were so serious at the time?
Our position throughout the trial was clearly that the prosecution was not able to establish, could not establish beyond a reasonable doubt that Brent or Raylene Worthington denied medical care to their daughter. Mr. and Mrs. Worthington never foresaw the harm that would come to their child. They thought she was getting better. There were signs that she was on her way to recovery. All the other members of the family had gone through similar illnesses, and everyone had recovered. It was completely a shock and surprise to the Worthingtons that Ava died.
Now, we haven't gotten to the end of our coverage of your trial yet, as you know. But let me ask you this question this way. Coming into the trial, how confident were you in the idea of putting your client, Brent Worthington, on the stand to testify in his own defense?
Well, we always knew that Mr. and Mrs. Worthington would have their chance to explain the situation from their point of view. There are many cases where defense counsel doesn't know, doesn't commit to whether the defendant will testify until very late stage in the trial. In this case, we knew all along that Mr. and Mrs. Worthington would testify.
What about, and we've talked about this on the air before in the various programs here as part of our coverage, and essentially the statement by your clients, the parents of this child, and nobody doubts at all that they loved their child, but a statement saying essentially if they had it to do over again, they still would have followed the same path and not brought in medical personnel. Tell us about that, and does that, in your mind, did that create a major problem for you in terms of how the jurors would look at them here?
Well, I think what it shows is a very high level of sincerity and faith and confidence that Mr. and Mrs. Worthington have always felt as to the well-being of their child.
I imagine, and putting myself in the courtroom, if I were the prosecutor in response to those statements, my argument to the jury would be that shows you exactly how little regard they had for their child's well-being, that if they can sit here today knowing that their child died as a consequence, they still would not have done anything different that could have saved her. How do you answer that argument?
Well, the way I would answer that argument is that nobody knows the future. Nobody knows what's going to happen. We can't judge people's conduct based on outcomes that were unforeseeable at the time. Certainly, if I went out on the street and I got run over by a train or a bus or a car, you might say, "Well, gee, knowing that, maybe you shouldn't have gone out on that street that day." But nobody knows the future. We can't know what's going to happen. We can only make our decisions based on what we know at the time. Oh. And Mr. and Mrs. Worthington, like everybody else in the world, we go through life and we make the best choices we can. We don't know how things are going to turn out. We do the best we can based on the knowledge that we have at the time.
Well, Mark Cogan, as you said from the very beginning, this is it's a fascinating trial for a lot of reasons, certainly a tragedy for your clients and everybody involved here. But we appreciate you taking some time to talk with us about this. Thanks very much. You take care.
All right. Thank you very much. I appreciate it.
Mark Cogan, again, the defense attorney for Brent Worthington inside of this courtroom. We're going to step aside for a quick moment. When we come back, we take you back inside of the courtroom, more of that testimony. It's the prosecution attempting to prove exactly how this 15-month-old child died, and more importantly, why. We'll be right back.